I'm Nicolene Skumanlo.
Hi, I'm Robyn Shepherd.
Hi, I'm Johan and welcome to our podcast. We are attorneys practicing at such at Skuman Law in Cape Town, South Africa. Today we'll be talking about interdicts. Now, just to give a brief example of where this would be of application would be, let's say that you have a neighbor and your neighbor starts building a pool, but you notice that your neighbor's pool seems to be encroaching on your property. In order to stop your neighbor from building his pool, you would have to apply to court for an interdict, which would direct your neighbor to stop building the pool.
Yeah, I think interdicts take many different forms. And by example, one of the most typical would be the situation where we have a property encroachment or a property right encroachment of some sorts. I think we also need to look at interdicts that go a bit broader than that. Let's say you're unhappy with something happening in a commercial or business setting. Maybe what your business partner's doing all sorts of things and you've tried everything else, then you could potentially also interdict him or her to do something. It could be active or it could be passive, where you say, stop doing something. And then, of course, the Americans refer to this as a restraining order. So maybe, Robyn, I can pass over to you. We don't call it that. We call it a protection order in South Africa. So what does that look like?
Yes, so protection orders, for the most part, in my experience, I've used it in terms of, family context. That's really utilized in our courts quite often. And that can really range from anything. It can prevent, it's used as a preventative measure. The protection order is to prevent someone from either physically abusing someone. It can range from refraining from making contact with someone. So it's really case by case, but it's something that is definitely utilized in our courts quite often. And it's a very good mechanism if someone is having a bit of trouble with someone on a more personal basis. So that is how we use protection orders in South Africa. And on that note, Johan, I wanted to ask you if you can explain to us really what are the two main types of interdicts that we get in South Africa, and how do they differ in their objectivity?
So, as Nicolene's already touched on, we have two types of interdicts mainly. You have a prohibitory interdict, which is an interdict which prohibits you from doing something. So the court will then direct that you must stop a certain action. And then you have a mandatory interdict, which is where the court will actually direct you to do something and say that, you must complete a certain objective or you must do a certain task as is required. And they obviously differ in terms of what their objective is. The one is obviously to stop a certain action, and the other one is actually to enforce a certain action and to say that it must be completed and you must do it. So, they ultimately apply in different circumstances, and I guess the facts of each case would dictate that. But, Nicolene, I wanted to ask you if maybe you can elaborate a bit on the application procedure of obtaining interdicts in South Africa and why pursuing it through a legal action is less common in this context.
Well, I think if we only focus on the court procedure, the application procedure, the first point I think we need to make is that it's an extreme remedy. That's, as legal practitioners, we refer to this as an extreme remedy, meaning that it's a last resort. You've tried a number of other avenues which have failed, and this is the only thing left available. So we need to always keep that in the back of our mind, that an interdict application is a last resort extreme remedy. And the courts really see it as such, because if you end up launching an application and you haven't tried anything else, you may very well find that the court will not grant your application. Motion proceedings are also fundamentally different to application proceedings. Now, I don't want to be too technical because, of course, as legal practitioners, we know what the differences are. But from a client point of view, or someone potentially tuning in today and listening to us, I think we need to draw a distinction between applications, which basically sets out your case in paper, and that is what you are confined to when you have your day in court. There's no testimony, there's no trial. Of course, depending on the situation, there could be oral evidence, right? But generally speaking, what we have in our papers is what will stand on and fall upon ultimately in a court context. Conversely, the action proceeding gives you room to lead witnesses, to interview people in the context of a trial, in other words, examination, cross-examination, and to test the version. Well, we don't have that in the interdict context, which means we have to be sure that when we bring that application, that we have exhausted all other remedies. This is our extreme last resort remedy, and that we've ticked all the boxes for the requirements that need to be met, and that the drafting really supports that. So I think it's when you have to write something down, and as a client, when you write your experience down, it's important to really look at it maybe from an objective lens, as a court may, and that your legal team assists you in doing that. Because the minute we have varying stories of what has happened in a particular context, we call it a factual dispute. The minute we have that, we've got problems, right? So particularly when it comes to the finality of our court application. So we need to be very sure when we go on motion or make application for interdict, or just generally speaking, that we can sort of anticipate what the response is going to be, and to try and accommodate for that, and to record the sequence of events and all the other things we've tried as best possible. So I think at this stage, maybe delving into the requirements a little bit deeper, I'm going to hand over to you, Robyn. So of course, we know it's a motion proceeding. We know it's on paper. We know we have to tick all the boxes, but what is the overarching requirements that would have to be met?
So firstly, the applicant must have a right, and that can either be a common law right or a statutory right. And the onus is really on the applicant in this instance to prove that he or she has a right. And once that's been satisfied, the next requirement is that there must be some form of actual or reasonable apprehension of harm or injury. And that just means that, again, the applicant must prove that there's some form of violation that's occurring. And once that's established, the next requirement is that there must be no other alternative remedy. So you've already touched on that, Nicolene, is that this is an extreme process that we start, and the court can refuse to grant an interdict if the court is not satisfied that the applicant has not tried whatever alternative remedy that applies in each case, and that's naturally a case-by-case basis. So those are your three main requirements that you really need to tie into when you're drafting your papers, as you've mentioned. You need to set out your facts, but throughout those facts, you really need to illustrate to the court that those three requirements have been met in order to be successful with an interdict. And on that, Johan, I wanted to know if you could just explain to us perhaps the distinction between a final interdict and an interim interdict, and really just highlighting the different circumstances under which these are typically granted.
So as we've touched on already, you know, this is an extraordinary remedy, and it usually involves a situation where someone's rights are being affected. And that's where the distinction comes in. An interim interdict is to give interim relief. It's a quick remedy where you approach the court and you say, listen, this is happening. There's a prima facie case to show that my rights are being affected. I need protection from the court in order to protect my rights. And then in those situations, should you be able to show that to the court, based on any kind of evidence, the court will say, listen, I'm going to grant you this interim interdict to stop anything or to direct that something must happen whilst the interim interdict is there. And then usually it would give a return date. And it's at that return date that the court's saying, this is the time for the parties to now come and prove their case, to prove that there is actually a right and all the requirements that you've mentioned. And once they've done that, the court will then decide whether or not to grant a final interdict. Now, the final interdict is obviously to say that this must now stop happening or you must do this. It's just to direct that there is a right, that the requirements have been met, and that the interdict should be granted. The idea is just so that there is no situation where, due to delays at court, someone's rights are allowed to be affected for an extended period of time. And that's why the courts allow for an interim interdict, which is temporary in that sense. It only lasts for a specific amount of time until the parties have time to come to court to prove their case and to prove whether or not an interdict should be granted. So I'd actually like to pass off to you now, Nicolene. And how do you think the judicial discretion plays a role in granting interdicts in South Africa? You know, what factors do you think the courts consider, especially in this context?
I think that's very difficult because it depends on the case at hand. But again, it goes back to making sure that as someone considering an interdict as a remedy, that you have the conversation with your attorney and that you ask these questions, and that potentially the attorney gets the opportunity to spend a little bit of time to look at similar situations and latest cases from the highest court, right? So we know on that point that our local divisions, in other words, our high courts in the particular province we are in, binds the decision-making for itself and the lower courts. And only the Supreme Court of Appeal or the Constitutional Court has the power to have a national binding effect. And therefore, it's quite important for us to look for cases where we have a bit of an indication on how the courts view our client's particular application. It is also important to note that you have to have a well-established legal right based on which you're seeking to protect your interests. So if we don't have a legal right, this is probably not the right remedy to execute. So at the end of the day, our courts are always in a civil sense, always in the delicate balancing position of looking at probabilities in a civil sense. How probable is our version versus the other version, which is more probable? And on that balance, is there a right that should enjoy protection? So again, from the words I'm using, hopefully you can hear that even our courts do not take this lightly. So it really can't just be a copy-paste scenario, and we can't guarantee how things will specifically be viewed by our courts. And that's why other cases that came before in the correct province with the correct binding effect becomes a critical tool for navigation. And that's really where your legal advice that you get from your attorney becomes really valuable. I know that some interdicts you can actually go and apply for yourself, particularly those dealing with domestic violence and so on. We have a huge problem in our country when it comes to issues of that nature, but it could still serve you well, particularly on the return date when the finality is going to be considered. I mean, a lot is at stake for you to actually ensure that you take proper advice and you are dealing with it properly. Even though there are ways in which you can get it done yourself, I do think that's where we are specifically positioned well to add value. So Robyn, I'm going to hand over to you so we can wrap up. Of course, I've touched on it that involving an attorney or a legal team that really knows their stuff can add value. But what are some of the things that we've seen happen when people actually take a stab at doing it themselves, and after the fact, you know, we get involved? And as you know, sometimes we really just can't turn back the hands of time. We can't fix it. Sometimes it's just, you know, something we have to restart correctly. So what are your insights in regards to that?
So from my side, I think I would touch on the domestic violence aspect and the family law aspect of it all. We touched on protection orders previously, and the complexities or difficulties around that. It is a very touchy subject, first of all, and it's a very personal, usually it's a very personal matter at hand. It's family members, it's friends, it's perhaps your partner, your husband, your wife. And the complexities around that is that ultimately, not all the time, but you don't always get the full end of the story. And then you go to court, and as you mentioned before, Nicolene, your matter is really based off of your papers. So you need to be able to draft properly and appropriately. And if you don't have all the information, that's when you have a bit of trouble when you get to court. And you obviously have to consult your client again. But the complexity with that is that not your client won't always be truthful to you, because, like I said, it goes back to it's a very sensitive matter. And as much as your client wants to get that order against, whether it be their husband, partner, wife, whoever it is, they also take their feelings into account. So it's very much a delicate balance between your client, what they want, and how they react to their specific family member, if it is based off of their family member. But another, complex thing that we do come across is also establishing the 3 requirements that we mentioned, is that establishing whether your client actually has a right here. Like we mentioned as well, the interdict, it's not something our courts take lightly. We need to be able to really establish that from the get-go. And to establish that, we also run into a bit of issues, not all the time, but sometimes that doesn't get done as well. So it's to just really make sure that we've been able to really meet all 3 requirements, and sometimes it's not always that easy. But based off of that, we just wanted to say thank you, and please like, share, and comment in the box below. And if you have any suggestions, please feel free to let us know. And please do join us in the next episode, where we will be talking about child maintenance when there is an issue about money. Please do join us.